No. Good afternoon, Mr. Stephen.
Good afternoon, my lord. This afternoon we have a panel of 4 representing the Law Society of Scotland and committees or subcommittees of that organisation.
Good afternoon, everybody. Afternoon. Right, you're going to be asked some questions. When you're ready, Mr. Stephen.
I'm obliged, my lord. Just a gentle reminder right at the outset that the hearing is being transcribed, so please do try and speak slowly and clearly and try not to talk over one each other. I'm sure you're far too polite to do that, but just a mild warning at the beginning. If I could start then first, please, and with you, Mr. Lang, and we'll work our way down the line, just to each of you to confirm your full name, your role, both now and during the pandemic, if that has changed, and also the remit of your respective committee, if applicable. So if I could start with you, please, Mr. Lang. Thank you.
Yes, so I am Kevin Ronald Lang. I'm the Executive Director of External Relations at the Law Society of Scotland. And if I can just, on behalf of the panel, if I can just start by offering on behalf of the organisation our sincere condolences and sympathies with all of those who have been affected and continue to be affected by the pandemic.
Thank you. Mr. Munro.
Yes, Stuart Kenneth Munro. I'm a solicitor in private practice based in Glasgow at Livingston Brown. I am currently convener of the Law Society's Criminal Law Committee. I became convener, I think, in May 2022, it's set out in my statement, but I was a member of the committee at the time that COVID began.
Thank you.
Shona Houston-Smith. I'm also a solicitor in private practice. At the time of the pandemic, I was a partner and head of the family law team at Balfour Manson. I am now a partner in the family law team at Blackadders. I also sit on, as a committee member, on the Child and Family Law Subcommittee of the Law Society.
Thank you.
I'm Linda Ann Towers. I'm currently the convener of the Mental Health and Disabilities Committee, which is part of the reason why I'm here, but I'm also convener of the Constitutional Law and Human Rights Committee. During the pandemic, I was a member of both those committees, but I became a convener just at the beginning of 2024. My background is as a government lawyer for well over 30 years, and I'm also currently, and have been since 2018, therefore all the way through the pandemic, I was a member of the Mental Health Tribunal Service as a legal convener.
Thank you all very much. And each of you has provided a written statement to this inquiry, and those statements have been disclosed to co-participants. For the inquiry's record, the references for each of those statements is as follows. For Mr. Lang, that's SCI-WT 0226-5001. For Mr. Munro, that's SCI-WT 0522-5001. For Ms. Smith, SCI-WT 0554-5001. And finally for Ms. Towers, SCI-WT 0467-5001. Now, we have limited time today, but please rest assured that everything that is in those statements will be taken into account by the inquiry and form part of its record, even if we don't touch on each and every aspect of those in your oral evidence today. Now, with those housekeeping matters out of the way, the intention of these impact hearings, as I think you all know, is to hear about key issues and impacts encountered by the justice system during the COVID-19 pandemic in Scotland. Time permitting today, the aim will be to cover the following topics in turn. Firstly, just a brief overview of the role of the Law Society of Scotland. Secondly, the key issues and impacts faced by the Law Society as an organisation. Thirdly, issues and impacts faced by members of the Law Society, i.e. the solicitor profession, due to court closures as a result of the pandemic, including those solicitors that were working in the legal aid sector. Fourthly, impacts felt by court users, whether that was clients, witnesses, complainers, due to court closures or other restrictions. Issues or impacts arising from the use of remote hearings, perhaps by video or telephone during the pandemic. Issues or impacts arising from the physical reopening of courts. Seventh, the use of emergency legislation during the pandemic. And then finally, I'd like to try and give you each an opportunity, if we have the time, just if there's any potential or particular lessons that you feel need to be learned that you would wish to share with the chair to the inquiry. So if I could start, please, with a brief overview of the Law Society of Scotland, and I think I'll come to you, Mr. Lang, for that purpose. Could I start firstly just by asking you how many members the Law Society represents, please?
So as of today, we have around about 13,000 Scottish solicitor members of the Law Society.
Thank you. And could you give a brief overview of what the role of the Law Society is, what its functions are, please?
Yes, so the Law Society is the professional body for Scottish solicitors. We are, first and foremost, the regulator of the profession. We set the route to qualification. We admit solicitors into the profession, issuing practising certificates. We set and enforce standards. But as a professional body, we also offer services and support to the profession. And on top of that, we've got wider responsibilities from statute in terms of the public interest, the consumer interests, and the rule of law.
Thank you. And I think the Law Society also perhaps seeks to influence changes to legislation also in relation to the justice sector, would that be right?
That's correct. So certainly with regards to our public interest responsibilities, we scrutinise legislation both from the UK and Scottish Parliaments, offer our suggestions for how that legislation can be improved, because it's in everyone's interests that there is good law that is passed by Parliament, that is understandable and that is workable.
And we'll come back to that issue at the end, hopefully, if we can. Thank you very much. If we turn then to the pandemic, the initial stages of it, please, and the impact on the Law Society as an organisation. And again, I'd like to start with you, please, Mr. Lang. When the pandemic arrived, was there any immediate concern about the funding or financial viability of the Law Society of Scotland?
Yes, there was. So around about 80% of the income from the Law Society comes from our members in terms of the core fees that we charge on an annual basis. And inevitably, when the pandemic hit, there was significant concern in the organisation that we would see a drop in the number of individuals taking out practising certificates. And so there was a concern that that would have a potentially significant impact on our income and our ability to finance the organisation.
And did those concerns materialise?
Thankfully not. And in fact, one of the encouraging elements of the pandemic from the legal sector was that the profession was actually very resilient. So we saw no drop-off in the number of solicitors. And in fact, today, even since the pandemic, we've got more practising solicitors today than ever before.
And did the Law Society have to incur any expenditure in terms of the change to ways of working caused by the pandemic?
Yeah, so there were two elements to that. Obviously, like many employers, we had to move to remote ways of working. That required a significant upfront investment in IT, physical IT, online platforms, not just for our staff, but for our many volunteers that take decisions for the Law Society through our committee structure. But we also, as an organisation, took a decision at an early point in the pandemic that it was important for us to do what we could to provide financial support to the profession. So our Governing Council agreed to a £2 million package of support for the profession, which involved a significant cut in our core membership fees.
Thank you. Move on then to the impacts felt by the Law Society's members, the solicitors' profession, due to court closures or other pandemic restrictions, including those that were working in the legal aid sector. And this will involve drawing upon your respective experiences and expertise. This might include, for example, any financial impacts that you were made aware of on firms or solicitors operating, mental health impacts on the profession, departures from the solicitor profession, impact on traineeships perhaps being offered, any other cohort of the solicitor profession that perhaps you consider to have been disproportionately impacted by what happened during the pandemic. I think on this we'll start with you again, Mr. Lang, but then we'll work our way down the line, and after you've spoken we'll come to Mr. Munro, Ms. Smith, and then Ms. Towers. So if I could start with you, please, Mr.
Yes.
Lang.
So we know, because we did extensive surveying of the profession throughout, that around about a quarter of solicitors were furloughed in some way, shape or form. And like ourselves, we made use of that scheme which the government provided. So it was clear that was a very important scheme that helped with that resilience that I talked about earlier. On top of that, the Scottish Government provided a legal aid resilience fund. We did see, well, we had pressures within the legal aid system even before the pandemic hit. We have those pressures today. That was one part of the sector that we were most concerned about because of its potential exposure to a drop in business and the viability of firms to carry on. So we worked hard with the Scottish Government to try and ultimately successfully secure a dedicated package of support for the legal aid sector, which included support for taking on trainees, included an increase in legal aid fees themselves, and also a fund which firms could apply to for additional support, which recognised some of the upfront costs which those firms were having to incur unexpectedly.
Now, you mentioned it there, and I think you do so in your statement also at paragraph 55. I think the word you use is the fragility of the legal aid sector even prior to the pandemic. Why do you use that description?
So the legal aid sector, in particular the criminal defence bar, has been a part of the profession that has been struggling for some considerable period of time. Around about a third of criminal legal aid solicitors are due to retire in the next decade. We as an organisation have described this as a crisis, a developing crisis in access to justice. That was the case very much in 2019 going into the pandemic, partly because legal aid fees have not kept up with rising costs, and many solicitors are now choosing not to undertake legal aid funded work and are leaving the legal aid sector altogether. So that was the fragility that existed even before the pandemic hit. And I think the pandemic exposed that fragility significantly.
And I think you mentioned making representations to the Scottish Government about legal aid during the pandemic. How swift and or adequate was the financial support offered by the Scottish Government in respect of those that were working in legal aid?
So the support which was made available came from February 2021, so a significant period into the pandemic. Obviously, we would have liked to have had that support at an earlier stage, but I think it is important to recognise that ultimately the Scottish Government did recognise the particular pressures which existed in the legal aid sector and responded with not an insignificant amount of financial support. Of course, we would have liked to have had that at an earlier stage.
And one of those, I think, one of the package items in relation to legal aid you mentioned, I think, was interim fee arrangements being brought in. What was the uptake in respect of interim fees? I think in your statement you perhaps suggested that the uptake on that wasn't as quite what you'd expected it would be.
This is probably an area where one of my colleagues will be able to kind of talk to it in more detail. I don't have those figures, but we'd happily come back to the inquiry with a follow-up note if that would be helpful.
Okay, thank you. Before I move on to Mr Munro, I just wanted to also ask you, Mr Lang, in respect of traineeships, because again that's something I think you cover in your statement. Can you speak to the impact or not on the availability of traineeships during the pandemic?
Yes, so as I said in my witness statement, we did see, not unexpectedly, a significant fall in the number of traineeships that were being offered, and I think that reflected the financial uncertainty which existed at the time. Taking on and maintaining a trainee is a significant investment of time and money for a firm. So we did see a drop-off in trainees. Again, I think what was encouraging for us was that the profession bounced back very strongly in the period that followed the pandemic. Indeed, over the last couple of years, we've seen record numbers of trainees being registered, and that in turn is feeding through to what I talked about earlier on, which is a record number of Scottish solicitors. So I think our experience was that it was more a case of traineeships being deferred rather than cancelled, and I think the figures back that up.
And you mentioned at the beginning of your evidence that the Law Society is obviously the regulator of the solicitor's profession. Given the switch to remote working, was the supervision or support of trainees a concern? And as the regulator, were you having to modify your approach to how trainees would be approved or ticked off to be qualified solicitors.
Yeah. So I think there were two elements to that. Obviously, from our perspective as the regulator, it is incredibly important to maintain standards. And we wanted to ensure not only that traineeships were getting the proper experience from their traineeships, but also they were being equipped with the right skills to be admitted to a profession that has very high standards. And we had to issue considerable guidance to allow for remote supervision of trainees. So we tried to be flexible as a regulator, recognising that in-person supervision was going to be a challenge. And we provided significant guidance around that. Our regulations also allow for traineeship periods to be extended for a period if that is the right thing to do. There was quite a significant uptake of that, and I think that flexibility was important.
Thank you. Could we move on to Mr. Munro, please? Thank you.
Yes, thank you. I agree entirely with everything that Kevin has said. I think it is important to recognise that the profile of the criminal defence part of the profession is quite different to the profile of the profession as a whole. Criminal defence work tends to be funded by legal aid. For a very substantial number of years, there have been real concerns about the viability of criminal defence work when funded by legal aid, largely because of the real term fall in legal aid fees over a quarter of a century or thereabouts. What that has meant, pardon me, is that firms tend to be smaller practice units, very often comprising 2, 3, 4 solicitors rather than a bigger unit. They tend to be profiled differently in the sense of tending to be older, more experienced solicitors. There tend to be much fewer in the way of new assistants or trainees going into that area of the profession. The other important aspect to appreciate is that in certain types of criminal defence work, the work profile tends to be relatively high turnover, relatively low value, relatively high quantity. And the problem with the pandemic was that that quantity suddenly disappeared. That firms which were configured to deal with a relatively high throughput of business in a given period, maybe a new case that starts today and is finished in a couple of months, for instance, that throughput suddenly ended. And as a result, the ability to charge, the ability to raise invoices for work done disappeared almost overnight. So the combination of these factors meant that there was a very immediate pressure on those doing criminal defence work in a way that perhaps larger entities doing perhaps longer term, higher value business maybe didn't feel in quite the same way. The other consequence of that different profile, the different practice unit type, is that smaller firms tend to have less in the way of IT infrastructure, tend to have less in the way of advice and guidance as to how they might cope with shocks such as the immediate move to remote courts or remote working. And an older profession, solicitors who are older and maybe are either likely to have greater needs for their own health to require isolation or caring responsibilities for elderly parents, were perhaps more likely to be affected by some of the complications created by the pandemic. So for a whole range of reasons, I think criminal defence solicitors found the impact of COVID to be very significant indeed. As Kevin says, there were measures put in place by the government after a sustained period of time into 2021, including the Resilience Fund, including arrangements regarding payment of interim fees. But ultimately, if there were no fees capable of being charged, there were no interim fees that could be raised, and that would not necessarily help almost a year after lockdown began.
Thank you. And I believe in your statement, Mr. Munro, you talk about it being a collegiate profession. And
yes.
I think the pandemic perhaps resulted in that being taken away when the subject matter of what's being dealt with is serious. And I think that's a mental health impact perhaps is also what you allude to there amongst the profession.
I think that's entirely right. That, again, one of the relatively unique features of our profession, and in particular the criminal defence bar, is the collegiate nature of it. Firms are able to exist as small units because they see professional colleagues. They interact with professional colleagues on a daily basis in court, in common rooms and the like, and all of a sudden, again, that connection suddenly ended.
In respect of the financial viability of criminal defence firms, are you aware of any examples of firms perhaps having to dip into reserves or savings to enable those entities to continue to run?
The benefit, if you can call it that, of being a smaller practice unit is that the overheads tend not to be so substantial. But many firms operate essentially as sole practitioners, and other than having to find a way of paying the salaries of staff, many solicitors effectively felt that they were unable to work for a period of time and found themselves having to rely on savings or support of family members in order to pay the mortgage. It's difficult to be clear on how many people that affected. People would not necessarily volunteer that they were in that situation. People would find it very embarrassing, perhaps, to admit that they had financial difficulties. But certainly many solicitors that I was aware of at the time were facing real difficulty in keeping the ship on the road.
Thank you. Could come to you now, Ms Smith, please.
Yes, I think in child and family work there is a range of solicitors and solicitors' practices dealing with it. For those working in legal aid, much of what's just been said in relation to criminal practice was the case for family lawyers. Working in court work for child matters mainly, where the same type of difficulties that have just been described for criminal practitioners existed for family practitioners. The point in relation to the collegiate nature of the family group of solicitors in any one area and the interaction which took place in a bar common room and the loss of that, I think had a great impact on many family practitioners at the time.
Yes, because I think paragraph 48 of your written statement, I think you talk about that, about family and child law practitioners, encountering challenging and distressing matters, as a matter of course, that's the job, but not necessarily having the office environment that you had before to be able to deal with that or to talk about with a colleague.
I think many solicitors working in family law at the time would talk about the fact that family law involves dealing with people who are already normally anxious, who are not at their best place because they are going through a terribly difficult personal situation. During the pandemic, frequently these people would still be living in the same house as the person they wanted to be separated from. So there were all sorts of very difficult situations. You had solicitors who were dealing with matters from their homes with all the emotion and the angst and the difficulty coming into solicitors' homes with nobody then to go immediately to talk to about that. For solicitors who were parts of bigger firms, you could go on to a Teams meeting and try and deal with it that way. But for many small firms, the way in which that would traditionally have been dealt with would have been to chat to fellow colleagues when you were next up at court, and there was no ability to do that.
Thank you. Ms Towers, are there any particular impacts on the profession you would wish to highlight?
I think, yes. I mean, our sector is quite different in a lot of the solicitors who were dealing on the mental health side, who were representing, for instance, mental health officers and putting the paperwork together, were working for local authorities. So they would be subject to the same difficulties as everybody else, because I think there were some lockdown situations and furlough situations there as well. The relationship between the mental health officers and the lawyers in the teams was very difficult, and maybe we come to that later, in looking at access to the courts to ensure that the timescales were met and that the paperwork was all appropriately moved forwards. In the context of the solicitors who were appearing for patients in tribunals, almost without exception, these were small firms, and therefore would have been affected by the same kind of issues as been described there. I don't know whether or not those firms were furloughed, but certainly they tended to be small firms that would have all the difficulties of a small firm trying to keep going in those particular contexts. As far as the mental health tribunal members, obviously all the tribunals are convened by a legal convener. I didn't anticipate that that caused any difficulties during the context of the tribunals and the pandemic, because the tribunals very quickly went to telephone hearings. So there was no requirement for people to be moving out of their houses. So I don't think it affected the membership of the tribunal in the same way.
Thank you. And we'll come back to telephone hearings in due course. Thank you very much. If we can move on then to key impacts felt by court users, whether that's clients, witnesses, complainers in the criminal context, due to the fact that courts were closed or in light of other pandemic restrictions. Again, drawing upon your collective experience. This might, for example, in the criminal context include impacts on the accused in respective periods in which they're held in custody or subject to limitations on their liberty. In the family law context, that might involve impacts on ongoing separation processes, divorces, child law matters. In mental health context, it might be the progression of cases or delays or variations of guardianship orders and matters like that. On this topic, please, could I start with you, please, Mr. Munro, and then we'll work our way down the line again and come back to Mr. Lang at the end, if that's all right.
Of course, the pandemic obviously led to the interruption of the justice function in a greater or lesser extent from the very outset. Certain functions of the criminal courts continued almost all the way through. The custody courts, for instance, sentencing hearings in High Court matters tended to take place, and I remember coming through to the High Court in Edinburgh and being able to park in the Royal Mile, which gives you an indication as to how strange a time it was. But the bulk of the criminal courts effectively ceased to operate for a period of time. Procedural hearings were automatically discharged and continued. Trials were abandoned for a lengthy period. I forget exactly, pardon me, how long it was, but for several months at least, no High Court trials took place. For a much longer period, I think getting on for a year, no sheriff and jury trials took place, and summary trials were abandoned for a lengthy period as well. Now, the practical impact of that is obviously felt by accused persons who find themselves either in custody for much longer than would have been the case before, or subject to restrictions on their liberty for much longer than would previously have been acceptable. It was felt also by complainers, and it's important to stress that the Law Society represents solicitors from across the piece, and the Criminal Law Committee too, that we are not simply reflective of those engaged in criminal defence, but also those who represent the interests of complainers and other people who are affected by the criminal justice system. So you had complainers who had to wait for justice in cases. You had witnesses who were worried about the prospect of giving evidence, who found that process delayed and delayed. And even beyond that, and even in what might be regarded as the less serious forum of the summary trial court, you had allegations that affected families that were delayed for an interminable period. So, for example, allegations of domestic abuse, where a father might have been accused of assaulting a mother. The father is excluded from the home because of bail conditions, maybe is not able to see the children because of those bail conditions. The impacts were far and wide. And I think it's almost impossible to tell what legacy that will have left. There were people who were in custody serving sentences who didn't receive the necessary training to allow them to progress through the rehabilitation process while in custody. That will have had an impact on how long they spent in custody. It will have had an impact on the experiences that they had and their families had following their release. So in a whole range of ways, there will have been serious impacts on a whole range of individuals because of the limitation in the justice function during COVID.
Thank you. And I think another example you give at paragraph 83 of your statement, Mr. Munro, is in relation to bail application cases. Also, I think in the issue of tagging, could you just explain what that issue was during the pandemic?
Yes, when courts are considering whether or not to grant bail, one consideration is the risk of that individual offending pending determination of the criminal case against them. And one way of controlling that risk or moderating that risk is through the application of electronic monitoring, a tag. And that requires the local authority in the particular court area to have the facility for assessing the individual's suitability for such a programme, and then for monitoring it and reporting back any instances of non-compliance to the court. Again, we saw that in certain local authority areas that function was lost or was severely limited, and that took away a potentially valuable option from the courts. Because one way in which you can deal with this difficulty in having so many people facing remand in connection with allegations that are taking much longer than usual to come to a conclusion is to have that additional option of electronic monitoring, but in many areas that was simply not available.
Thank you. Come then to you, Ms Smith, on the family law perspective, please.
Yeah, I think that the impact on many of the clients or families that family solicitors were working on was immediate, because I think the day the first lockdown was announced, there was an interview given by Michael Gove on national television first thing in the morning, initially saying that where parents were sharing the care of children and they were passing between homes, that they couldn't do that anymore. And then about an hour later he went on a different channel and he corrected himself. But it sort of set the tone for how it was going to be over the coming weeks, because in families who are living in separate homes, the norm is for children to pass on some basis between two homes. That seemed to initially clash with the rules that had come into place at the start of lockdown. So families, even well-intentioned people who wanted to do the right thing, just didn't know what the right thing was. And at that stage, as the solicitors' profession were trying to move to working at home and setting themselves up working at home, you were having to deal with clients who were asking for answers that we just didn't have to give them. And that led to all sorts of difficulties in those families, which had long-lasting repercussions, not just in the coming weeks, but in how the family interacted with each other moving forward. The Lord President did issue guidance on the 27th of March, where he tried to regulate the position as best he could, because by saying that, you know, that this was a matter for parents and that they had to be sensible and they had to act in the best interests of children, and in due course that if it was reviewed, that you know, there would have to be an explanation for different decisions that had been taken. But it did leave a degree of uncertainty. It left it open to different interpretations as to what that meant. There were very well intended positions adopted by parents about whether it was or was not in their children's best interest to leave the house and travel to another house, especially if there were older relatives, or if somebody was shielding, or if somebody worked in a profession which meant that they were coming into contact with others. The fact at that stage that the courts had closed down altogether didn't just affect the people who were in court. In most family solicitors deal with families in all sorts of different ways, but the vast majority of our work is with people who resolve their issues out with the court system. But we are able to do that and to negotiate that by reference to what would happen in court. And when you take that away, those first few weeks of lockdown were a very good example of what happens when you take away the recourse to the justice system in relation to that aspect of matters. There was an impact in relation to financial matters for many families, because if you couldn't go to court to ask for financial support, then there was no need to negotiate with the person who wanted to avoid payments. So at a time where financial matters were an issue, if you were looking for spousal support, so interim aliment, pending resolving matters, there wasn't an ability to do that, which again caused greater anxiety and uncertainty. When we were able to start having hearings again, and they were dealt with on an urgent basis, there was varying practice throughout the courts, in sheriff courts in different parts of the country, about what was deemed to be urgent. So again, it was difficult to give your clients any certainty in relation to that. So in terms of a family lawyer's client base, you're working with people whose lives already in a state of disarray. It's uncertain. There's a lot of anxiety. The emotional impacts, both on the adults and the children, was very considerable.
Thank you. If we could come to Ms Towers, please.
I think the people that were being dealt with in terms of my committees are generally vulnerable. Their families quite often are vulnerable as well, but for different reasons, some of them for the same reasons. And I think one thing, as far as perhaps the mental health tribunal side, is the easier side to deal with, because there are strict rules within which certain things have to be done. And generally, while certain of the procedural elements were altered throughout the period of the pandemic and then really sort of made easier and then perhaps tightened up again, generally the requirements of the time limits in context of the mental health tribunals were met. I think the difficulty was in the wider areas of things like guardianship orders and powers of attorney. And there was a huge increase in people seeking, not surprisingly, because it made life easier, powers of attorney and guardianship orders. With the guardianship orders, that immediately got into the difficulties of how far the sheriff courts were able to deal with those particular timescales, and the powers of attorney in relation to the Office of the Public Guardian, because they were obviously off on furlough and working from home. So there were difficulties, and procedures were put in place to allow the most urgent of powers of attorneys to be registered so they could be used. But the difficulty with the guardianship orders is that they became subject to some of the provisions which made stop provisions in relation to particular orders in the courts. So one of the cases I've referred to, where it was anticipated a guardianship provision would be considered within a 6-month period, wasn't, because it was allowed to carry on for a longer period, and the sheriff in that particular case was anxious that it wasn't a longer period at that time, and that it should have been reviewed within 6 months, which it wasn't. And I'm sure there were other cases of that particular kind that were caught. So families, there was uncertainty there. They didn't know when it was going to next be reviewed, how it was going to be caught up. There were also difficulties in accessing both individual homes to take statements from people, both by the lawyers who were coordinating it or taking statements, but also the psychiatrists and the mental health officers who were having to input to the lawyers to deal with the various applications. People just couldn't access, couldn't move around. Hospitals kept obviously locked down, and then it became an issue, perhaps a disproportionate issue later on, because you still need reports even during the process of particular orders. The hospital ward might have been open, and then somebody gets COVID and the whole ward gets shut down again. So access for solicitors into the wards to see clients, and access for the psychiatrists and mental health officers in order to allow the applications to be processed became a real problem. So uncertainty that others have referred to, and the nature of the clients in this case who were particularly vulnerable. And there were also questions about people being within homes where they might be a risk to the other people within the homes, because without the appropriate reports they couldn't be moved on. And there were all sorts of questions about deprivation of liberty around that.
Thank you very much. Mr Lang, was there anything you wish to add on this topic?
I think it's just worth saying that on court closures, the Law Society, our members, recognised why that was a necessity. It was done on the basis of professional advice and intended to keep people, our members, their clients, safe. It's important to recognise that. The stark truth, however, remains that we are dealing with the consequences of those court closures today. And I know the inquiry has taken evidence from others on this point, that we are dealing with a backlog of cases. We went into the pandemic with a backlog of cases. The backlog is around double in some cases, depending on the level of court, double that it was in 2019. The time that it is taking from an offence to a verdict is double what it was before. And so it therefore is the case that we are in a worse position today to withstand another pandemic of this kind than we were in 2019, just by the very virtue of the sheer number of cases which are sitting to be disposed of. So I think if there is an accepting that it was the right decision at the time to keep everyone safe, I think there's more work to be done to look at how can we better withstand an event like this, because we cannot continue with the kind of backlog and the delays which we are seeing today. And we often use this phrase, justice delayed is justice denied. But whether you are a complainer, whether you are somebody who has a case brought against you, it is in nobody's interests to be sitting waiting years for a decision from the justice sector.
Thank you. I'm conscious of time and we have a lot to cover, so I will move on. I want to touch next on the panel's experience of remote hearings during the pandemic, whether that was by video or telephone, and issues that you may wish to cover, and it will be your evidence to give, but it may be things like digital exclusion, any effect upon ability of solicitors to take instructions from their clients or to consult with their clients, the ability of clients to effectively participate in hearings of whatever nature they were, the quality of the technology that was available for those hearings to be conducted, and the panel's views on the effectiveness, I suppose, or efficiency of those hearings, whether in respect of procedural or indeed evidential hearings. On this, if I could start with Ms. Towers, please, if I may.
Yes, we started very quickly in the mental health tribunal area to move straight to telephone hearings. My personal experience is, as I say, slightly different from the overall experience of the tribunals, in that when we started moving out, we moved very much at a speed that was possible, because hearings were happening, in-person hearings were happening in hospital rooms, so they had to be big enough to have for all the distancing and all that kind of stuff and the various facilities. So it was a gradual process. Now, it started with the odd hearing using WebEx, which was better than being on a telephone hearing. But again, to go back to the kind of people that you are dealing with in that kind of context, they are vulnerable people. They are probably, some of them, very unwell, and they are hearing a disembodied voice at the end of the phone. Now, it worked, and we still do hearings of that kind in the tribunal if the patient wishes it, and sometimes there's a good reason why they might wish it. But from the point of view of the tribunal and a convener, if you like, keeping control of a hearing, the person can't see you, you can't see how the person is reacting, you can't see if the person is becoming unwell. Usually people were supported on a ward or in a hearing, but wasn't always possible in the context of some of the worst times of the tribunal. And very often their solicitor wasn't sitting beside the patient, and the solicitor plays a very important role in keeping the patient calm, explaining to them, and that just wasn't feasible during that period of time. So I think for the patient, the vulnerable kind of patient, that was undoubtedly, more difficult. In the wider context of dealing with court cases, and in the context of preparing all the information and people appearing back in the sheriff courts again, I've already explained the difficulties of even access to the courts in the early days. you might have a sheriff in there and you might have a sheriff clerk in there, but actually knocking on the door and getting them to open the door could actually be a bit of an issue, even because they were, getting the paperwork in could be a problem. It all worked out, and at the end of the day, I think people worked out that certainly in the context of hearings for the vulnerable people who were in the mental health tribunal, you had to make that as inclusive a procedure as possible to enable them to get the most, and that's one of the obligations under the mental health legislation. And I think most tribunals tried to do that, but it's difficult to say how successful we all were at the end of a telephone in a very different and distant place with somebody who didn't know who it was that was taking a decision about them.
Thank you very much. Mr. Lang?
Yeah, I think colleagues will be able to offer specific examples and experiences. I would better than I can, but I'd probably say this one general point. I think there was an interesting distinction during the pandemic between the profession, which is actually a reasonably digitally switched on part of society and the economy, and clients, which solicitors help. And I think there was some naivety early on in the pandemic to assume that clients, users, would be able to take part in digitalisation of court proceedings in a very simple and straightforward way. As Linda said, often solicitors are assisting some of the most vulnerable individuals in our society, those from deprived communities without access to the kind of IT infrastructure that you and I have got access to, the digitally excluded. And I think, again, in terms of lessons to be learned, I think it is about ensuring how do you ensure that you can deal with business efficiently, but do so in a way that a client, the ultimate user of the justice sector, is going to be able to understand and participate in and have confidence in as well.
Thank you. Mr. Munro?
Yes, thank you. In terms of remote hearings, these in the criminal justice system came in a number of guises. The most immediate was custody appearances, so where somebody's arrested by the police is appearing for the first time before a sheriff. And there were various pilots that were undergone in different courts around the country. I think the experience of that was very mixed. One could see the benefit of having individuals kept at a police station or custody centre where necessary services and supports could be made available, such as health or psychiatric support and social work, and where one didn't then have vans bussing accused persons around the country and being held in often inadequate accommodation in sheriff court buildings where social distancing couldn't be achieved. So one could see the benefits that were potentially to be given by such a system, but the experience was mixed. The quality of technology was very variable. The WebEx system that Scot courts have used generally through the justice system didn't apply in the custody court model. It tended to use a Polycom system that had been adopted by the police, as I remember. The quality of the image, the quality of the sound was very often poor. There were real concerns about the ability of an accused person to effectively participate in the proceedings, even to just see and hear and understand what was going on in what, after all, were very important decisions being made about them, their case. And there were real difficulties in accused people having private communications with solicitors. The nature of the custody court, if one goes to Glasgow or Edinburgh on a busy Monday afternoon, one can see dozens of cases involving dozens of people running about trying to make the whole thing work effectively. Instructions can be taken from an accused person prior to their appearance, but that depends upon papers having been served, it depends upon information being forthcoming, and very often there's a need to go back and speak to the accused person again before an appearance. And the remote custody model simply didn't facilitate that. The practical effect was that custody courts very often took an awful lot longer than they would have done under the old model, and as I say, there were real concerns about the way in which they worked. Sheriff Principal Lewis of Tayside Central and Fife issued an evaluation paper which effectively said this system could work, but it requires substantial changes and it requires substantial investment, including at the police station end, where there needed to be better facilities and better resources. Sheriff Principal Anwar of Glasgow and Strathkelvin is now convening a working group looking at how a gold standard custody court model could be developed for use in the future. And I think, going back to Kevin's point about making preparations or ensuring the resilience of the system pending a further shock, then that is one very effective way of trying to do that, regardless of the benefits that such a system could have in any event. The next category of cases might be summary trials. Now, as I said earlier, they shut down for a sustained period. They were the last of the trials, as it were, to get up and running again. And we still have a pretty significant backlog of summary trials to get through. There was a limited pilot of remote summary trials, so that's entirely remote, where everybody was joining on WebEx, that occurred in Grampian. The difficulty was in getting cases to actually participate in that project. I think about 10 cases were heard all in. It seemed to work relatively well. There weren't any serious concerns about the manner in which it operated. Sheriff Principal Pyle is leading a pilot group looking at trauma-informed domestic abuse summary trials, and that has been combined with other reforms to the criminal justice system in summary cases to try and find the best way of dealing with domestic cases from the point of view of accused people, complainers and witnesses. That has taken longer than might have been liked. I think one issue is whether or not it will receive support, including financial support from government. But again, the aim of that is to try and improve the experiences of court users across the board. You asked, or you mentioned earlier, about the issue of digital exclusion. And that's a very valid point, pardon me, that one has to consider how individuals can participate in a remote court process. And that gives rise to challenges. Do accused people, for instance, join from their homes or from prison, or do they join from solicitors' offices? Or do they have to come to court to join from there? And where would the solicitor be in that model? But I think it's important not to lose sight of the fact that there is already justice exclusion in our system, that a system that requires people, particularly in rural areas, to travel 20, 30, 40 miles to go to a local sheriff court for a procedural hearing that might take 5 minutes excludes people effectively from the process. A system that requires trials to take place a long way away from where a complainer might reside has the potential of excluding people from the process. And there are arguments that certain types of remote hearing can increase inclusion on that basis. I think it's a two-way process that one has to take into account. Just to finish off on the point of the remote experience, we had, and we continue to have, a number of hearings conducted remotely, such as preliminary hearings in the High Court. That's a process that works well and has the support of the profession. And indeed, as we came out of COVID, it moved back to in-court, the in-court model, only to give rise to real consternation amongst the profession, who found that they then had great difficulty in adjusting to that. Busy advocates who already have commitments in trials found it very hard to be in another High Court building for a preliminary hearing. And so there was a move back to the use of remote hearings in a way that, as I say, I think works very effectively. And then the final point I would make related to the use of remote juries during the pandemic, which in my view was a tremendous step forward for the Scottish profession and something that Scotland should be truly proud of, because it was an innovative high-tech model that allowed serious criminal trials to be restored and restarted much more effectively than was the case south of the border, where instead of adopting remote models, they simply reconfigured courtrooms to try and have jurors sitting 2 metres apart from each other. The Scottish model was a very innovative response to a very challenging set of circumstances. It was put in place remarkably quickly, and it's a matter of regret that A, there was no effective evaluation, as I understand it, of the pros and cons of the system and the experiences of those who used it, and B, it was effectively shut down come the end of the pandemic simply because of the cost, as I understand it, involved. And it's a pity that we haven't done more to try and learn from the experiences that the remote jury model gave us.
Thank you very much. Come to you now, Ms Smith.
Yeah, I think something else that needs to be commended is that if you think about where we were at the start of the pandemic in terms of the operation of our courts and how quickly we moved to any form of remote hearing, it was impressive. At the outset of the pandemic, in the Court of Session, there was more of a practice of dealing with certain matters by email and email documents, but in the Sheriff Court, we were still at a stage where you had to physically either post something to the Sheriff Court or turn up a bar of court and lodge it, and within a matter of a couple of months that had changed entirely. So I think sometimes it's important to remember that, is that there was huge progress. That having been said, when we talk about digital platforms, I think what gets forgotten, I think, sometimes is the reliance that was placed on telephone hearings, not just in those first few weeks and few months. I think I heard of a telephone hearing taking place last year. It carried on in certain sheriff courts in the country for a very long period of time, indeed, and certainly beyond the period in which this inquiry is considering. And the telephone hearing system in terms of families was far from ideal. There was a varying practice throughout the country. In some courts, clients could join the hearing. In others, for technical reasons, only solicitors could join the hearing. So if you were dealing with child welfare hearings, which is a type of hearing where there will be the sheriff and both parties and clients in a court normally, with the sheriff being able to speak both to the clients and to the solicitors, and the solicitors being able to speak directly to their clients as well, that was replaced with the telephone call with solicitors and the sheriff and the sheriff clerk. You mentioned about taking instructions. Certainly in the early days, it was virtually impossible in some of these hearings to take proper instructions because your client couldn't hear what had just been said. And where there was the patience and the time on the part of the court, it would mean coming off the call, making another telephone call, phoning the other solicitor, and hearings that would have taken a relatively short period of time, taking an hour or more. Those telephone hearings continued in some courts, as I said, for a very long period of time, and I recall a discussion taking place in 2021 in the subcommittee where a solicitor mentioned that there had been a child welfare hearing at which a parent had been deprived of all contact with their child by telephone when they weren't present, and that was not good. But equally, in the Court of Session, we, by memory, I think, moved towards WebEx hearings by the June, and certainly my main court in which I was practising is Edinburgh, and by memory, I think we moved to WebEx hearings by about August, certainly that year. And it worked well, subject to what's already been said in terms of digital exclusion. So for clients who did not have access to the technology or the ability to use technology, it was problematic, and there, in my experience, was a reliance on solicitors being happy to have clients in their firm, in a room in their firm, where they could access technology and it would be dealt with in that way. So by that stage we're talking about the autumn. That was dependent on the solicitor being comfortable with doing that, and so that created, by memory conversations at the time, a tension occasionally where there was almost an expectation that would be a solution, but for solicitors who were uncomfortable for all sorts of good reason and working in small firms where they couldn't just say to a colleague, well, could you do that part and I'll do the submissions, then that was problematic for the solicitor. as well. But in general, particularly for procedural matters, WebEx hearings worked well and continue in my experience to work well. I think in terms of evidential matters, they were more problematic. I can remember a number of issues arising in relation to sharing of documents, for example, or people being able to access screens properly, or having consistency of connection, or whether you could be satisfied that there was nobody else in the background overhearing or passing information. There were all sorts of issues that came about in terms of evidential matters. But for procedural matters, I would agree entirely. In terms of access to justice, it increased access to justice. It reduced, for those clients paying privately to use the court system, it reduced the cost for those clients if the only time their solicitor was engaged was when they were in court, as opposed to travelling time. There wasn't as much waiting time in general.
Thank you. I want to move on then, again, conscious of time, to key issues experienced by members of the Law Society on the physical reopening of courts once that was able to happen, and that might include, for example, in the panel's view, whether the court estate was sufficient for court users, and by sufficient, whether that means in terms of physical distancing, again, the ability to obtain instructions or to hold consultations with clients, the operation of hub courts, the communication and dissemination of information by courts, whether COVID restrictions were being adhered to by those in the court estate, whether that's by staff or users, experience of any sanctions that were in place for that, including contempt of court, and whether any of those issues had a corresponding impact upon the profession, including, for example, their mental health, if there were, for example, sanctions being suggested. If I could start on this topic, please, with Ms. Smith, and then we'll go to Ms. Towers and back along the panel, please.
I think, picking up on your point in relation to communication, that was a feature that was problematic from the outset, and again it depended on which court you were in, where you were in the country. So in the Court of Session, there was a relatively small group of practitioners working within the court. There were dedicated family judges, they were dedicated clerks, and it worked well. There was very good communication, but it was easier to do that because it was a smaller group. In sheriff courts throughout the country, there was information by way of guidance given in different ways at different times. So in some sheriff courts or sheriffdoms, there was formal guidance published. In many, however, the information which solicitors, clients, party litigants needed to be able to access the courts properly and conduct cases was dealt with by way of emails, for example, email to a bar association to disseminate information to members. When in advance of coming here and talking to other solicitors who were practising at the time, I was reminded on more than one occasion that in some instances you were reliant on tweets and social media to tell you how it was you were meant to deal with things in separate courts. The issues which had always been present in relation to the varying practices of the sheriff courts throughout Scotland became more difficult to deal with when you couldn't just pick up the phone to the sheriff clerk anymore, because prior to the first lockdown, that's what you would do. But after lockdown, and to a large extent it's the case to this day, is that phoning sheriff courts is not something that can easily be done. So the way the sheriff courts work is that you email, but that doesn't necessarily bring a response in the time frame that's necessary. So one example I can give is of being excluded from a hearing because an incorrect link had been sent out, emailing the court to let them know what was going on, no answer, nobody answers the phone. So in terms of communication, both about general issues and communicating about urgent, immediate issues, there were significant problems in my experience in how information was given to practitioners.
Thank you. Ms. Towers.
From the the question of the sheriff courts, I think that was very much a difficulty for those dealing with it in the community in the context of the powers of attorney and guardianship and things like that. The same issues in gaining access to the courts were a big issue. People were going across sheriffdoms, and different sheriffdoms had different guidance as to how they were dealing with particular issues, and it wasn't always possible, well, not easy possible, I don't know what the word is, to access that information to ensure it was being done as expeditiously as possible. There were also issues, as I mentioned before, in actually phoning the sheriff courts and getting somebody to actually pick up the phone and answer questions on timescales. In the context of the tribunals, I think it was less of an issue in the context of information, because once it had got from the practitioners in the community into the tribunal service, they were then in charge of the process of communicating documentation and information. I think the concern at that stage was quite often with an unwell person receiving a whole lot of papers. It's someplace in a hospital. Who's going to read it out to them and explain what it actually means to them, and getting access to proper private telephone access to allow that to be done. So there were concerns as to whether or not perhaps people were explaining. Because of the difficulties in getting documentation together, I say the tribunal has to be strict in what it meets with timescales, but that inevitably means that a lot of the stuff comes at the last minute. So what's happening is the patient then doesn't understand what's going on, or they need further information, and therefore you tended to get more interim orders being made at that stage. Therefore that increases the hearings, which is an increase in the cost, but also perhaps in distress to the patient and the uncertainty for the patient or the unwell person. So there were certainly issues around that in relation to communications. On the outcomes of the decisions, again, that worked in the sense that the decisions were sent out by the tribunal service, but again, who's going to explain it to the client in quite the same way as sitting down and explaining why particular decisions were being made? So that, I think, was more difficult. But solicitors would just have to find a way to do that, and it would have to be done on the telephone, which was less helpful, but had to be done.
Thank you. Mr. Lang?
So I think it's firstly important to recognise that there was a genuine and sustained effort by the Scottish Courts and Tribunal Service to engage ourselves as the professional body for solicitors and other interested parties, Crown Office, Scottish Legal Aid Board, Faculty of Advocates. So there were forums in place that allowed for difficulties, stresses, strains to be brought out into the open and discussed. And that was very much valued from our part. Indeed, actually, some of those structures have sustained to this day. So that collaboration has continued. I do agree with what's already been said, however, that with the fairly devolved nature of our justice system to sheriffdoms, sheriff principals, there were in some cases very different arrangements from one sheriffdom to the other. And for us as a professional body trying to provide accurate guidance and signposting for our members, that was a real challenge. Now, inevitably, different buildings will have different physical requirements, and that was always to be expected. But separate from those, there were instances where there were different required practices that our members couldn't understand as to why it was that case in one part of the country and why it was different somewhere else. So I think consistency where that is possible is always appreciated, and where you cannot provide that consistency, explanations as to why that is the case and ensuring there is excellent communication throughout is essential. The only other point I would make that's separate from what's already been said, I think certainly when the courts were reopening, there were discussions around how do you ensure, yes, that the courts reopen safely, but that you also maintain fundamental principles of our justice system. So, for example, one of the suggestions that was going to be rushed through in an emergency piece of legislation was juryless trials. That is a significant change to a fundamental aspect of our justice system. And ultimately, that was not taken forward. But certainly in the discussions that we were having, both operationally, but also with Scottish Government at a policy legislating level, there was a need to also articulate the importance of the rule of law, the rights of the accused, the right to a fair trial, and the risk that in a rush to try and deal with the immediate pressure, there was a risk that you could undermine some of those principles.
Thank you. And one question just before I move to Mr Munro. Was the Law Society made aware of any concerns from members in respect of, I think for example, Lord Justice General issued a statement in 2021 about the possibility of those that were in the court being found in contempt if they weren't adhering to restrictions. Was there any concerns from Law Society members about that, the statement that was made?
So I don't recall concerns being raised with us about that. Again, as the regulator, we expect solicitors to work to high standards, and that includes meeting the requirements that are set down by the court. I cannot recall any systemic issues being raised with us about non-compliance by solicitors. Can I say here and give you an absolute guarantee that every solicitor at every point as the courts were reopening never made a mistake? No, I can't give you that assurance. But the impression I very much got was that our members, solicitors, adhered to the standards. And certainly, had there been any systemic issue, I would have expected that would have come about or would have been raised with us through the forums that I talked about before, and I can't recall that being an issue at the time.
Thank you. Mr Munro.
Thank you. I broadly agree with everything that's been said by my colleagues on this topic. A couple of points if I can make briefly, though. First thing to say is that the court estate inevitably was not configured for social distancing. That had two primary impacts from our perspective. One, when the courts reopened, there were limits placed on who could attend, and that meant that accused people, witnesses, complainers weren't able to take along people for support in the way that they might otherwise have done, and that would have changed the experience that they had in the court process. Secondly, even purpose-built courts, like the Saltmarket High Court building in Glasgow, for instance, have interview rooms such as they are that are very small. And in many cases, these interview rooms have fixed seating. You can't move the chairs around to try and increase the space. And that creates real practical difficulties for obtaining instructions. Now, it's of course the case that practitioners will do all they can to ensure that they have proper instructions before they come to court, as one would expect. But it's important to recollect that very often they are representing vulnerable clients who can find it difficult to engage prior to a court hearing. And secondly, that things can happen at court. There can be sudden disclosure by the Crown. There can be a development in the case that requires instructions to be taken. And that made a real practical impact, or had a real practical impact on how those instructions could be taken, given the absence of sufficient interview room facilities in the court estate. The system worked, I think, because of the tremendous amount of goodwill that everybody involved in the system showed. Solicitors who are experienced in doing criminal work or other types of litigation work generally will find a way around problems. So they would find a room in the court building that wasn't otherwise occupied. Maybe an empty courtroom, for instance, could be used for a private meeting. As Kevin says, I'm not aware of any instance where there was a formal complaint about anybody not complying with guidance. I think generally speaking, people tried their best to comply. I was aware of the Lord Justice General's comments. I think that maybe created a degree of tension or irritation perhaps from certain quarters. The Glasgow Bar Association, I think, put out a statement about it. But fundamentally, I'm not aware of anybody being found in contempt or being seriously threatened with contempt because of non-compliance, and nor am I aware from my own experience in the courts of any instance where there was serious concern about any individual's failure to comply with the guidance. The position was one of general compliance and goodwill, and we saw that on a day and daily basis. The final point I would make, if I may, and I appreciate it was maybe slightly beyond the purview of your question, but it's relevant to the experience of those doing criminal defence work, was in relation to police station advice. So before a case gets to court, when a client is in police custody, either requiring advice before a court appearance or perhaps when facing an interview and indeed being interviewed by the police in connection with a serious crime, solicitors are routinely called upon to assist clients in that situation. Interview rooms in police stations across the country, and indeed even in the most modern of facilities, tend to be very small and very cramped. The desk that I'm sitting at with my two colleagues here is typical of the size of desk that will exist between, on the one hand, an accused person and a solicitor, and on the other hand, two interviewing police officers. Very often the room is no more than a couple of metres square. And the measures that were put in place to try and tackle the risk arising from COVID would typically involve a perspex screen that was placed between the one side of the desk where the solicitor and the accused were seated and the other side where the police officers were seated. The point being that it gave no protection whatsoever to a solicitor from an accused person, or indeed vice versa. And because these tended to be cramped small rooms with very little, if any, ventilation, there were concerns about the risk of exposure in those circumstances. Again, when one has in mind that we can often be dealing with vulnerable people who might not be themselves aware of their own risk of infection. So that was an area that caused real concern amongst the profession about the extent to which they were being put in that difficult position. Now, the Society's advice was always that solicitors should never put themselves in a difficult position or a position where they felt that their health was going to be at risk. But clearly, people felt a degree of pressure to comply. They didn't want to get in the way of an interview taking place. They didn't want their clients to spend longer in custody than might be necessary. And I think that was an area that was never really properly addressed and that would be useful to be considered were another pandemic to take place.
Thank you. I'm conscious our time is up, or a minute over actually, but I think what I'm going to suggest we do is, rather than take the role of emergency legislation as a discrete topic, we'll perhaps roll that up with any lessons learned, and I'll just give you each an opportunity to say anything specific you wish to the Chair in respect of any lessons learned that may or may not include that role of legislation during the pandemic. So if I could come to you first, please, Mr. Lang.
I will take your lead on that, Stephen. I mean, so that is one area that I talked to in my my written statement around some of our concerns around the use of emergency legislation. It's right and proper that Parliament have got those procedures to legislate in an emergency where that is required, but Parliament is not a hindrance to the legislative process. It is an improving component of legislation, and we all see legislation that ends up better than it was when it was first introduced to Parliament. So I think the limited use of emergency legislation is an important principle. I would also say that, again I mentioned this in my evidence, at one point we ended up with 32 versions of the coronavirus health regulations. Law is good when it is understandable and clear, and I think it was a challenge when you had all those different versions trying to understand what was the most up-to-date situation. And finally, the distinction between the law, regulations and guidance, I think it got very confusing throughout the pandemic, and it was difficult for us to understand and to provide that information to our members. I would simply finish by thanking the inquiry for allowing this opportunity to focus in on justice issues. I think so often it can be the case that justice can be overlooked as a sector in situations like this, and so certainly on behalf of the Law Society, I'm very grateful for having had this opportunity, so thank you.
Thank you. Mr. Munro.
Thank you. I would say that one lesson that has been learned from the pandemic is that the criminal justice system is now much more aware of the potential benefits of technology in delivering both criminal and civil justice in the 21st century. Technology provides the additional benefit of resilience in the event that we were to encounter another pandemic in the future, but that we should learn from the good and bad experiences that we had in the pandemic while memories are still relatively fresh, and design systems that meet the needs of the 21st century, that allow for effective participation, that allow for all of the other side benefits that potentially could flow while addressing the concerns that were legitimately expressed at the time. And if we can design systems now, we will benefit from them now and benefit from them in the future.
Thank you. Ms. Smith.
Yes, I think one issue which has been highlighted by the pandemic is the need for clarity, to pick up on the point of clarity, clear communication coming from the courts in a way that is accessible by all court users, whether they be solicitors, party litigants, clients, to ensure that the court system can be used properly by all court users.
Finally, Ms. Towers.
I would absolutely agree with what Kevin said about legislation and guidance, and from my background as a government lawyer and a head of the Parliament, you would expect me to say that, and I think there were excuses for that at the beginning of the pandemic. I've done emergency legislation myself, instructing it, and you need to do that, but that went on far, far longer, beyond a stage where that needed to be the case. There was time to have updated legislation and to avoid, I think the one Kevin's referring to, I actually counted it up and I got 36 amendments in this particular, and that's just not on really. And the question of guidance, that guidance is guidance and not legislation, a lot of people didn't understand that. The second thing that I would just like to briefly deal with is a question of consent and the question of the use of the Social Work Act, and I have referred to that in my statement, but there are real concerns from a human rights point of view that patients were being moved from hospitals to care homes to other care homes, where they may not have had capacity to give consent to that, and they were not asked to give consent to that. And there are real questions there arising out of deprivation of liberty and general rights as to where they should be staying. That was a major issue. On the question of procedures and going forward, we're facing at the moment a huge review of the Mental Health Act legislation and the Adults with Incapacity Act legislation, which covers all the various areas that the Mental Health Committee certainly deals with. And I would hope that perhaps in looking at that the government will take account of whatever is considered from a process point of view that might arise out of this inquiry, by way of recommendations, and incorporate that into how they are proceeding with the review that will be going on for some considerable time yet.
Thank you. Thank you all. Well, Lord, I don't have any further questions for the panel.
Yeah, thank you. No, I'd just like to thank the Law Society and the members of the panel. I had the Scottish Courts Administration, our representatives in the Scottish Courts Administration here this morning, and much what they said echoes what you've been saying this afternoon, to be perfectly frank. And one thing that they were very keen to emphasise was how much progress they made in a very short period of time. And from my own personal experience in courts, I actually happen to agree with that, and I'm very glad to hear that you broadly agree with that as well. And I did take the opportunity to say to them, and I may as well say it to you, that I did comment on the fact that I was the oldest person in the room. I'm probably still in that category. But in almost 50 years in the courts, I saw more progress in 2 years following or during the pandemic than I saw in the 40-odd years before. And I think it would be jolly good if we could carry on with that. So thank you all very much indeed.
Thank you.
Very grateful. We adjourn until tomorrow morning at 10 o'clock.
Yes, my lord.
Thank you.